The Supreme Court striking down President Trump's tariffs. The president and his scathing response right here tonight. The nation's highest court saying the president exceeded his authority when it comes to most of his tariffs.
The 6-3 decision had the court's liberal justices joining with 3 staunch conservatives, Chief Justice John Roberts and 2 justices appointed by President Trump himself, Neil Gorsuch and Amy Coney Barrett.
I'm ashamed of certain members of the court, absolutely ashamed, for not having the courage to do what's right for our country.
Welcome to State Line Media. Let's get started. Chief Justice Roberts' opinion in NFIB versus Sebelius remains the sharpest constitutional accountability tool we have. That ruling cut the individual mandate loose from the Commerce Clause, then rescued it by relabeling it a tax. And that single move built the precedent we're now watching play out. Under the commerce power, Congress can't force people into economic activity.
The president railing against the justices tonight, calling the decision a disgrace and ridiculous, saying he's ashamed of some of the justices, calling them fools and, quote, disloyal. Economists say these tariffs on other countries end up being a tax on Americans, that American businesses buying those overseas products pay the higher costs because of the tariffs, and then that cost is passed on to the American consumer. Well, tonight the president vows to work around the court's ruling. Also, what happens to the more than $140 billion collected in tariffs?
But the taxing power lets it achieve much the same result. The real constitutional problem was never the outcome itself. It's the structure underneath it. When emergency authority starts functioning like a hidden tax system, pushing economic compliance without any explicit taxing authorization from Congress, Roberts' own reasoning turns into the case against it. The line he drew so carefully between regulation and taxation is precisely what now exposes today's administrative overreach.
All national security tariffs under Section 232 and existing Section 301 tariffs, they're existing, they're there, remain in place, fully in place, and in full force and effect. Today, I will sign an order to impose a 10% global tariff under Section 122. And we're also initiating several Section 301 and other investigations to protect our country from unfair trading practices of other countries and companies.
5 statutory tools survived this ruling, and together they show exactly what got struck down and what didn't. Section 232 lets the president impose tariffs for national security reasons based on a Pentagon review. Section 122 allows balance of payments tariffs for up to 150 days without any emergency declaration. Section 201 permits safeguard tariffs once the International Trade Commission finds injury. Section 301 addresses unfair foreign trade practices through a USTR investigation. Section 338 covers discriminatory foreign trade treatment based on documented findings. Congress never lost its legitimate tariff powers. The court simply struck down the one tool operating completely outside any of these statutory boundaries. This isn't a resignation-triggering event because tariffs disappeared.
Yeah, Renee, look, a long-awaited result from the U.S. Supreme Court on the use of IEEPA tariffs by U.S. President Donald Trump. The court has ruled 6-3 in favor of the fact that the use of Donald Trump's tariffs and the imposition of those tariffs was unlawful. And so 6 of the judges ruling with the court's ruling to deem the imposition of these tariffs unlawful, 3 of them providing dissenting opinions saying that they do believe that they were lawful. But ultimately, this means the Supreme Court is ruling against the use of U.S. President Donald Trump's IEEPA tariffs.
It's significant because the one tool functioning as unchecked executive taxation just got dismantled using the most doctrinally precise reasoning available. That's where the refund exposure comes in, and it turns a constitutional problem into a financial one almost instantly. Every company that paid tariffs under IEEPA now has a documented legal claim that it overpaid the federal government. This ruling didn't just block future collections. It retroactively stripped legitimacy from every dollar already collected under that emergency framework, going all the way back to when the tariffs started. That's what makes this fundamentally different from a typical regulatory strikedown, which usually only prevents future harm.
The tariffs mean American shoppers could see prices go up on everything from clothing to smartphones to TVs to toys. The Chamber of Commerce saying tonight the president's move will inflict greater pain on American businesses, farmers, workers, and consumers and undermine an otherwise strong U.S. economy.
What would you say when China, for the last 20 years, has been taking hundreds of billions of dollars out of our country? So now it's time that we change things around. If they don't want to trade with us anymore, that would be fine with me.
Here, the entire collection history is now exposed. The tens of billions estimate isn't speculation. It's simple math applied to real customs revenue data against a legal authority the court just invalidated. Every major importer, every supply chain company, every business that reorganized around these tariffs now has grounds to file a claim.
We're awaiting a potential Supreme Court decision on IEEPA. We have not gotten it. The Supreme Court has finished their rulings for the day, and they have not ruled on Trump's tariffs.
Spoke about this last night in Detroit. He was saying, could you imagine the Supreme Court is trying to rule that my tariffs are illegal? But then he did say, we'll find another way. So for financial markets concerns, although everyone does want to know whether or not this is going to be deemed illegal, there's going to be a time period if it is deemed illegal where your companies are going to line up for refunds. About 75% of Trump's tariffs are tethered to IEEPA.
No constitutional ruling in recent trade history has opened up this exact mix of retroactive liability, documented collection records, and established legal standing in a single decision. That's not hype. That's the math of Treasury exposure speaking for itself. Legal experts offer the most important caveat here. Even a devastating Supreme Court loss doesn't automatically force a president to resign. That distinction is essential to engaging with this honestly instead of turning it into fiction. Supreme Court losses reshape what a president can do. They narrow legal interpretations and take tools off the table. But crucially, they don't remove a president from office on their own. Removal only happens through specific, limited channels: voluntary resignation, impeachment through Congress, or invoking the 25th Amendment through the cabinet. This tariff ruling doesn't touch any of those three paths. It strips away statutory authority, opens the door to massive refund liability, and could spark a political firestorm, but it creates no mechanism for removing anyone from office. Coverage that respects this distinction is built to last, not just to generate clicks. That's the real credibility gap in how this story got covered. How the administration actually responded gives us the clearest evidence against any "resignation is inevitable" narrative. Within days of losing at the Supreme Court, the administration publicly attacked sitting justices and rolled out a new 10% global tariff under Section 122. That timeline is a matter of record, not speculation. The ruling had wiped out the emergency declaration tariffs, and the response was to confront the judiciary head-on while immediately deploying one of the surviving tools the court had explicitly left untouched. That's not what resignation looks like. That's escalation, executed within the exact boundaries the ruling itself established. Section 122 survived because it operates inside statutory limits, and using it right after a court defeat shows a clear-eyed grasp of exactly what was struck down and what wasn't. Publicly attacking justices shows zero willingness to treat the ruling as politically binding. This isn't the trajectory of someone stepping down. It's documented defiance paired with a legal workaround. The resignation narrative collapsed the moment you looked at the actual behavior. The real constitutional crisis isn't whether Trump might resign. It's that emergency powers were being used to tax the public without congressional sign-off. And the Supreme Court named that problem directly. Roberts didn't hand down a political statement. He wrote a structural rebuke. IEEPA gives the president emergency regulatory power, not taxing power. The Constitution gives taxation to Congress on purpose explicitly. When emergency declarations start generating revenue through tariffs, they're functioning as taxes without congressional approval. And that's not run-of-the-mill regulatory overreach. That's a violation of constitutional categories altogether. The emergency power had turned into a shadow tax system, and Roberts took it apart using the same precise reasoning from NFIB versus Sebelius, where he separated commerce regulation from the power to tax. Here's what didn't survive: the the global 10% Liberation Day tariff, the fentanyl-related tariffs on Canada, Mexico, and China, and the entire framework allowing unilateral revenue-generating trade restrictions through emergency declaration. Every dollar collected under that system is now legally uncertain, with tens of billions in potential refunds on the table. Here's what did survive. Section 232 National Security Tariffs backed by Pentagon Review. Section 122 Balance of Payments Tariffs capped at 150 days. Section 201 Safeguard Tariffs requiring an ITC injury finding. Section 301 Responses to Unfair Trade Practices requiring a USTR investigation. And Section 338 Tariffs for discriminatory treatment backed by documented findings. 5 separate tools, 5 separate legal foundations, 5 procedural requirements that the emergency declaration approach completely skipped. This is where the refund issue stops being theoretical and becomes an actual fiscal emergency. Every company that paid these emergency tariffs now has a solid legal claim that they overpaid based on authority that was never valid. This isn't a future risk. It's a liability that already exists. The ruling didn't just stop new collections going forward, it undercut the legitimacy of everything collected since the tariffs began. Run the actual customs revenue numbers against a legal authority the court just threw out, and you land on tens of billions in nearly identical claims, all with the same legal basis and standing. So look at how Trump actually responded. It undercuts the resignation is coming story completely. Within 72 hours, there were public attacks on the justices, calling them politically weaponized. Within days, a new 10% global tariff was announced under Section 122. That's not the behavior of someone preparing to step down. That's confrontation immediately followed by a tactical pivot to the exact statutory tools the court left in place. The contradiction here is total and fully documented. You can't credibly call a ruling career-ending while simultaneously reporting that the same person deployed an alternative legal tool within the same week. The ruling took away one mechanism. The reaction was open defiance of the court paired with an immediate shift to a surviving legal option. That's the opposite of giving up. That's escalating within a new set of legal boundaries. Legal experts anchor this analysis in an important reality. Even catastrophic Supreme Court losses don't automatically remove a president. They reshape what a president can legally do. They strike down interpretations of statutes. They eliminate specific tools, but they don't trigger any removal process. A president can only be removed through one of 3 paths: voluntary resignation, impeachment and conviction by Congress, or a 25th Amendment cabinet action. This tariff ruling activates exactly none of them. The 150-day cap on Section 122 matters, but not in the way the resignation narrative implies. It's a time limit on this particular workaround, not a countdown to anyone leaving office. It's a specific window for balance of payments tariff authority, and extending it beyond that requires Congress to act. That limit shows this workaround was never meant to be permanent executive power. It's temporary authority that expires unless Congress extends it. That's constitutionally meaningful, and it's also practically significant for a second-term president trying to push a trade agenda within a tight 150-day window. This is what an honest read of the situation looks like. A major defeat on emergency tariff power, an important win on prosecutorial immunity, a 24 out of 28 success rate on the emergency docket, survival through quick statutory workarounds, and 0 rulings that create any path to removal. That's the real story. Not dramatic, not fatal, just ongoing institutional friction met with tactical adaptation. Calling this ruling catastrophic is accurate for what it actually did and misleading about what people think it means. It's completely accurate as a description of the emergency tariff strategy specifically. The Liberation Day tariffs are gone, the fentanyl tariffs are invalidated, and tens of billions in refunds are now on the table. But calling it catastrophic for the presidency itself is directly contradicted by the surviving toolkit, the Section 122 pivot, the documented response, and the actual constitutional mechanics of how a president gets removed. If this breakdown gave you more clarity than the headlines did, drop a blue heart in the comments so I know it's landing. Every claim here is fully documented. Learning Resources Incorporated versus Trump is the actual 6-3 Supreme Court decision on record. Roberts' language on the limits of emergency authority and de facto taxation comes straight from the published opinion. The invalidated tariffs are detailed in the ruling itself and in coverage from Reuters, Bloomberg, and trade publications. Refund liability estimates come from analysis by Covington, Aiken Gump, and the Peterson Institute. The surviving statutory tools are laid out in Title 19 of the U.S. Code and confirmed by legal experts. The Section 122 pivot is documented in White House announcements and the Federal Register. The mechanics of presidential removal come from Article 2, the impeachment clauses, and the text of the 25th Amendment. The attacks on the justices are on video from press conferences and posted on Truth Social. Every fact here traces back to an actual institutional source, not speculation. The ruling really is catastrophic. The resignation narrative really is fiction. Both statements are true because they're describing two completely different dimensions of the same event. Roberts' reasoning here traces directly back to the logic in NFIB. Congress can't force economic activity through Commerce Clause regulation of inactivity, but it can compel behavior through explicit taxation. That's the core distinction. When emergency power starts producing the same effect as taxation, without any of taxation's constitutional limits, achieved through penalty-based mandates with no congressional taxing approval behind them, that's a direct violation of the doctrine Roberts laid out. He set that boundary in NFIB, and he enforced it again in learning resources against emergency declarations functioning as tax mechanisms. The 5 tools that survived all share structural features the emergency declaration approach lacked. Each one requires a documented institutional finding. Section 232 requires a Pentagon National Security Assessment. Section 201 requires an ITC injury determination. Section 301 requires a USTR investigation into unfair trade practices. Section 338 requires documented proof of discriminatory treatment. Section 122 requires balance of payments certification. The emergency pathway, by contrast, only required a presidential declaration, and that procedural gap is exactly what doomed it. Process-bound statutory tools survived. The unilateral emergency declaration didn't. The court didn't kill tariff power altogether. It killed the one mechanism that bypassed every procedural safeguard the legitimate tools require. Put it all together and you get the full picture. Constitutional structure, fiscal exposure, behavioral response, and institutional dynamics, all pointing the same direction. Roberts struck down emergency taxation without congressional approval. Tens of billions in refund claims are now open against a documented history of customs collections. 5 statutory tools survived with their procedural requirements intact. Trump publicly attacked the court and deployed Section 122 within days. Supreme Court losses reshape presidential power, but they don't create removal mechanisms. What we're watching is grinding institutional conflict, not a fatal blow to the presidency. I'm Derek, and this is Republic Signal. If this kind of breakdown cuts through the noise for you, subscribe now. We dig into the constitutional mechanics behind every headline built to sell drama instead of substance. Next time someone tells you a single ruling ends a presidency, you'll already know which statutes to check, which constitutional mechanisms actually matter, and which real-world behavior contradicts the narrative. That's not entertainment. That's accountability literacy. See you in the next breakdown. Don't forget to like, subscribe, and hit the notification bell for more updates from State Line Media. Thanks for watching.